Good afternoon and welcome to our second installment of our employee benefit lunch break series. This is Tripp VanderWal, and for today's lunch break, I am joined by my friend and partner Jeff Gray, who will be talking about retirement plans, specifically partial plan terminations. And I'm going to be honest with you folks right now. Partial plan terminations is something that I even when Jeff suggested this topic, I thought that's a little boring and doesn't seem to come up that often. But he reminded me, in light of COVID, with additional layoffs, furloughs, and even terminations of employment, unfortunately, partial plan terminations are becoming a much bigger issue for certain employer sponsors of retirement plans. So he did get me to agree that maybe this was a good topic. Jeff, if you just forward it to the next slide on upcoming topics. So after the webinar today, you will get a chance to submit a review or a survey. And one of the opportunities during that survey is to suggest future topics for this lunch break series. And I really recommend that you do so. One issue that we saw is that our advertisements these are somewhat generic, and it would be helpful if we had, we're more specific, especially when we talk about specific topics like we are today. So we will definitely try to do this. We are new to this lunch break series is new, so we're kind of learning as we go, but it will certainly help if you are able to provide suggestions to stuff that you've got going on, or maybe you're interested and we can incorporate in future lunch break series. With that, I will turn it over to Jeff to take us through this exciting issue of partial plan terminations. Jeff, it's all yours.
All right. Thank you, Tripp. Good afternoon, everyone. Tripp's right. I'm responsible for this topic today. It has come up more recently. We've done some general employment updates, some general employee benefit updates for some of our earlier seminars, and this was a topic that generated a number of questions. So really, I picked this topic for a few reasons. One, we'll have a client alert coming out, I think, later next week or so. That's kind of an end of year client alert related to retirement plans. And we expect to cover a broad set of topics in that client alert. So we should be able to get you kind of general legal updates through that process. What I really want to do is spend a little bit more time digging into a particular topic. And this topic, I think, really anybody who works with retirement plans should be aware of it. It's particularly important now with the pandemic going on, but it's also important generally speaking. It happens, partial terminations come up in all kinds of different situations. So even if you are listening for a few minutes and you think, well, that doesn't really impact us this year, it may very well next year, it may very well impact you working with retirement plans for another employer. So I think there's just some value in spending a little bit of time here during a lunch break, getting into a few more details about partial plan terminations. The partial plan terminations, just very briefly, these are unique to retirement plans. It doesn't apply to health plans. It's important for large and small employers, really any employers who have a retirement plan that has a vesting schedule. As we'll get into in a minute about what a partial plan termination is, it really relates to vesting under your retirement plan. And as I said, it's just particularly important in today's environment. So what are we talking about when we're talking about a partial termination of a retirement plan? There's really two pieces to think about it. One, have we triggered a partial termination? And then two, once that's happened, what do we do about it? So the first bullet point there gives you just the general overview of what a partial termination is. The IRS views a partial termination of a retirement plan to have occurred really automatically whenever there's a significant percentage of employees who were participating in the plan are now excluded from coverage due to some employer-initiated action. We'll get into more details about what that really means, but that's the basic definition. The definition in the statute is super simple. It just says employees need to be 100% vested if there's a partial plan termination. Any participants affected by the partial plan termination must be 100% vested. The problem is, what did Congress mean when it said partial plan termination? And that's what's been left to the IRS to sort of unpack and describe for us over a number of years. And as you'll see, it's a little tricky the way the IRS has done that over the years. So,
hey, Jeff,
yeah.
I'm just going to interject. I'm going to take this opportunity to ask some of the questions that I have about partial plan terminations, if no more to ask some of the dumb questions I've had. So I guess, one underlying thing is the big difference here between a partial plan termination and just a complete plan termination is a complete plan termination is usually done with the employer's intent to do so. There's a board decision or some decision that the plan needs to be terminated, and it's very intently done so, where a partial plan termination may accidentally occur with no intent on behalf of the employer plan sponsor, correct?
That's absolutely right. It can happen without your intent. It can happen really right under the nose of HR and everybody else. And that's really part of the reason for doing this today, is to just make sure that people are aware of it, so that it's pretty easy to address this issue if you see it when it happens. It's much more difficult to address when the IRS tells you it happened many years later. So yeah, you're totally right. But let's talk a little bit about what plans are really impacted by this rule. Really, any 401k plan, any profit sharing plan, defined benefit pension plans are also covered by this rule. It's in section 411D3 of the code. Interestingly, it appears that it does not apply to 403B plans, only because that particular section of the code, 411D3, does not appear to apply to 403B plans. We don't have any guidance specifically from the IRS on this, but our view is that this doesn't apply to 403B plans. And of course, if you have a simple plan, those plans are always 100% vested anyway. Same thing if you have a safe harbor 401k plan. If everybody's 100% vested all the time in all employer contributions, then you really don't have to worry about this rule too much. But again, I think if you work with retirement plans generally, the next employer you work for may not have a safe harbor plan. I think it's good to just understand how these vesting rules work. So what triggers a partial plan termination? Really, the first thing we're looking at is, well, has there been a significant percentage of employees who've been affected by some sort of employer action that have excluded them from coverage under the plan? And this can happen in all sorts of situations, right? For this year, we've got layoffs to worry about. Indefinite long-term furloughs could potentially trigger this. I probably should have in parentheses put that's sort of a gray area. If you've got people on furlough and you expect them to come back as of a certain point in time, I don't think we'd really count those folks as having some sort of employer-initiated severance from employment. But if it goes on for a long period of time and we have no idea when people are going to come back, you could potentially have a partial termination as a result of furloughs. You could also have a plan amendment that just excludes a group of employees. That sometimes happens without people knowing it, where, for example, you've got a group of employees who are no longer eligible under a particular plan. They're going to be eligible under a different plan, and so now you've excluded them under the former plan. So you have to watch out for a partial termination there. Oftentimes, I think this often gets missed in the context of a sale of a business as well. So an employer has multiple operations, it sells off a division. Those participants if the company sells its assets, those participants terminate employment. They're presumably hired by the buyer. They have a new plan by the buyer. That could trigger a partial termination of the plan as well. Finally, there's a specific rule that applies to defined benefit plans. If you have a defined benefit plan and you reduce future benefit accrual, so say you've suspended them and reduced them, and that suspension of benefit accruals could result in a reversion of assets to the employer, you can have a partial termination. What that means generally is, if, say, your plan is already overfunded and you reduce benefit accruals, which could result in more assets coming back to the employer when the plan is finally terminated, you could have a partial termination as a result of that. It's really not a concern if the plan is underfunded, however. So how do we determine if a significant percentage of employees have been excluded from coverage? The IRS really looks at the facts and circumstances. That's what it describes in its guidance, which leaves us with, okay, what does that mean? It's somewhat helpful. The IRS also says, okay, in reviewing these facts and circumstances, we will apply a presumption. And the presumption is that if the employer's turnover rate is 20% or more, then we presume that a partial termination has occurred. And we'll talk in a second about how we might rebut that presumption in certain circumstances. But so you've got this turnover rate, 20% or more. And then the question is, okay, well, what period of time are we looking at here in calculating this turnover rate? And that's what the IRS describes as the applicable period. So you've got a turnover rate within an applicable period, which is usually the plan year. But that's really the first step. If we're looking at this turnover rate, say you've got some layoffs, say you're thinking there's a division that might be sold, a plant that might be sold. And keep in mind too, you look at that 20% number, that 20% number applies to large and small plans. So a smaller plan could be much more likely to be affected by these partial termination rules than a larger plan. But anyway, so you're planning, you're thinking that this might happen, you're wondering what to do. Well, the first step is really to look at, okay, what's the applicable period? The default rule is it's the plan year. Occasionally, if you have layoffs, for example, that are kind of planned together and spread over multiple years, then you might end up having to do this calculation over those multiple years. Then there's a unique rule that if you happen to be in a short plan year, you also count the prior year in doing this turnover calculation. So, okay, you figured out what your applicable period is. It's usually the plan year. Now what do we do? Well, step 2 really is to divide the number of participants who had this employer-initiated severance. And we'll talk a little bit more about that on the next slide. But you take how many employees did we have who had employer-initiated severance, or they were excluded by the employer under some amendment, for example, during the plan year. So you take that number during the plan year and you divide that number by the sum of 2 other numbers. And those it's simpler than it sounds, but you basically just take the number of participants in the plan at the beginning of the plan year and the new participants during the plan year. So you take those numbers, add them together, and then you divide the number of participants who had this employer-initiated severance by this number of participants in the plan year. So if I had 200 participants at the beginning of the plan year and I added 10, I have 210 total. Say I lay off 50. I then divide that 50 by 210 and I get a 24% turnover rate. And so in the IRS's view, that's going to look like you had a partial plan termination during this year. And at the very end of this slide presentation, I've got a slide that talks about, okay, how does the IRS actually find out about this if we happen to miss it? But again, keep in mind that there's sort of a disadvantage built into this system for smaller plans, because if you only have 10 participants in the plan that year and you happen to let 2 people go during the year, you could have a partial plan termination. So this slide just goes into a little bit more detail about what employer-initiated severance means. So what are we talking about in that denominator, the number of really affected participants? The focus is on involuntary termination of employment when you're determining the turnover rate. So you're looking at that turnover rate, you're looking at involuntary termination. So terminations due to death, disability, voluntary retirement, or other voluntary reasons are really disregarded as you calculate the turnover rate. So as you're calculating whether you've had a planned termination, you can generally ignore voluntary resignations. If there's a dispute about that, the burden's on the employer to prove that it was voluntary. So constructive discharge, for example, if you're kind of familiar with that rule where you just made it miserable there for this employee to work, that would probably count as an employer-initiated severance. You count vested and unvested participants in doing this calculation, so there's no difference there. And there's no exclusion for kind of good cause termination. So even if somebody stole money from your employer and was fired as a result, they still count in this denominator as you're trying to assess whether a partial planned termination has occurred.
So Jeff, the deck is really stacked against employers in these situations, right? I mean, first you start off that if you have a 20% turnover, there's a presumption that a partial plan termination occurred, and then when you're trying to fight that, if you're trying to prove that there was not an employer-initiated severance, that the burden's on the employer to prove that it was the employee voluntary terminated employment. So you're guilty until proven innocent, correct?
Yeah, pretty much. I agree with that. And you'll see here on the next couple of slides, the IRS in a couple of situations has just what seems like bent over backwards to protect employees, which is all good and fine, but it creates some confusion and some difficulty when you're actually trying to figure out how to deal with a partial termination. So yes, you're right. There's this 20% turnover rate. If that occurs, it's presumed, the IRS presumes that you've had a partial termination, but there are some exceptions to that. So if you're an employer and you just happen to have a really high turnover rate of 20% or more, and you can kind of show that that turnover rate is routine, then the IRS may accept that and understand that, okay, that's just sort of normal operating practice in this particular industry. And so we're not going to find that a partial termination occurred. And then in kind of rare circumstances, you could have a number below 20% trigger a partial termination. But usually that's just where the employer is trying to stagger this somehow to benefit highly compensated employees. You know, like maybe you let your non-highly compensated employees go in December in a number that's below 20%, and then the next, kind of percent that would get you to 20%, you let go the next year, and they're mostly highly compensated. And at that point, you decide that, okay, there's been this partial plan termination, even though you're not even up to 20%, but you've sort of fully vested these highly compensated employees. In those circumstances, if the IRS feels like you're doing something abusive, they may actually find that there's been a partial termination, even if the turnover rate's less than 20%. So assuming you've had a partial termination, then what do you do? The rule is that if you've had a partial termination of your retirement plan, each employee affected, so each affected employee must be treated as 100% vested in all employer contributions as of the partial termination. So the question is, okay, who are affected employees? There are some easy answers here, right? If you've had layoffs, the folks that were terminated as part of the layoff are clearly affected. If you sold a division or a plant, those folks would be affected employees. But beyond that, in sort of the margins or the gray area, it's a little bit unclear based on the IRS guidance, because what the IRS has said a couple different times in a couple different contexts is that, okay, we know, employer, that you've just spent a bunch of time figuring out if all of these involuntary terminations triggered a plan termination. And we get that you've just realized that, yes, a partial plan termination has happened. But when it comes to actually making people 100% vested, we also want you to include anybody who voluntarily leaves. So even if an employee voluntarily left, they are considered affected by the plan termination. There's no real reason for that. It doesn't really jibe with the legislative intent of the rule. People who voluntarily quit, how they're affected by the plan termination is a mystery to me, but that's the IRS's position on it. And here it is from the IRS webpage. When the IRS talks about affected employees, it's talking about anyone who left employment for any reason during the plan year in which the partial termination occurred, and who still has an account balance under the plan. And so it's not really even clear what that means. I mean, if I have layoffs in October and an employee voluntarily quit back in March, does that person need to be made 100% vested? They terminated during the plan year. Well, the last kind of underlying phrase there seems to suggest that that they're not considered affected if they left and they took a balance and they're gone. So if they're outside the plan, gone from the plan by the time the plan termination occurs, it looks like they're not affected. But what if they still have an account balance? I need to make this person 100% vested. It seems odd because they left earlier in the year. How are they really affected by this partial termination? And I think as a practical matter, a lot of employers it's debatable whether that rule about voluntary terminations really complies with the law. But at the end of the day, really what you have to do is just, for people who have an account balance, and make them 100% vested. And I think a number of employers just kind of err on the side of being generous, because why fight it? Why dispute it? If we know that we've got these people who left this year and they have account balances, let's just treat them as 100% vested. And keep in mind,
so this is like the ride.
Go ahead.
I was gonna say, this is like the ride for free doctrine, right? Like I voluntarily leave my employment. I don't get around to rolling out my funds for my 401k plan, but I clearly my severance was clearly voluntary, so I'm not at all included in the partial plan termination calculation. But if it happens, I potentially get the benefit of being 100% vested as well. Correct?
Yeah, that's right. That's exactly right. And again, these are kind of somewhat on the margins here with these people. It's very clear that you make the folks vested who had involuntary terminations of employment, who were in the layoff or part of the sale. And of course, the other thing to remember is that none of what I'm talking about applies to ongoing employees. So, or employees who terminated employment outside of the plan year. So we can kind of ignore those two groups. If you're still employed, you're still subject to the vesting schedule. And if you terminate employment a year after this partial termination occurs, well, that doesn't affect you either. So by process of elimination, we can kind of get down to the group of people who really should be made fully vested in the context of a partial termination. And there's some kind of on the margins that it's just good to talk to your counsel about how you want to handle those in the circumstances you're dealing with. And so what happens if, sometimes it happens that you just miss the plan termination, right? You didn't see it happen, didn't notice it, and the next year goes by, and wait a minute, somebody tells you that you missed it. Your lawyer or your plan auditor says, hey, there was a partial termination last year. What do we do about that? Well, a number of those affected participants probably took their money out, maybe took a distribution, and you may have caused them to forfeit their employer contributions as a result of that, when you shouldn't have, because they were an affected employee under that partial termination. And so really the correction there is that you have to restore that forfeited amount plus lost earnings. Normally it involves kind of reopening the account, depositing the funds, and then it kind of gets cashed out if the person, under the normal small balance cash out rules, if the person already took a distribution. And so if the forfeitures, and of course the forfeiture account should be spent down every year, that's supposed to be used every year, not carried over from one year to the next. So this may require an employer to actually kick in some money to correct these forfeitures that shouldn't have happened. And that's really what we're trying to avoid. We're trying to avoid having to do this, having to avoid this process in a future year, and having to avoid, kind of a nightmare if it went on for several years and wasn't corrected.
Hey Jeff, if this does happen and an employer needs to fix it, is there any de minimis amount? And what I mean by that is, let's say the individual forfeited $100. Now I have to make a contribution to the plan, basically work with the record keeper, contribution that includes lost earnings to the plan, which let's just say is also minimal. Work with the record keeper to, reestablish that individual's account. And then under the cash out rules, basically we automatically cash them out. So we send them a check after the typical withholdings, and prepare the form 1099-R. And by the time we're all said and done with this, the fees related to that person is maybe $300, only to send that, and their benefit is only $175. Is there any type of like de minimis where they can say, okay, it's just going to cost me more to do this than that person's even going to get? Can I skip that person?
Yeah, so that's a very good question. So if the participant has not taken a distribution yet, they still have an account, there's no de minimis. That just needs to be corrected, even if it's 5 cents. It's got to go into the participant's account. If the participant, though, has taken a distribution, they no longer have an account balance there, and you have to make a corrective distribution, which is what this would be. There's a de minimis rule in the IRS correction procedures. I think it's $75. So if the amount you would pay is $75, and the amount of actually doing the correction, funding it, paying it, mailing the distribution check. So the record keeper is going to pay you a fee for that. If that exceeds $75, you don't have to do it. And same thing if it's, if you're paying them, as long as it's under 75. So if you're paying them 25 and it costs 40 to do all the legwork to get it distributed, you can ignore that person as well. So that's a good question and a good clarification. This slide here, other considerations, I just intended to kind of bring up the corporate transaction rule again, just to keep it in your mind when you have a division or a plant that's sold off, that this could be an issue. There is an exception though, that if employees terminate as a result of a sale, and in the connection with that sale, the portion of the plan that they participate in is spun off to the buyer, who then continues to operate it. Well, those folks are considered to basically continue to be covered by the plan, and that's not a partial termination. So that's one way to avoid a partial termination if you have a plan, if you have a sale. So how are these partial terminations discovered? If you miss it, are you just in the clear, or might it be found later on? Well, it might be found later on. The IRS Form 5500 now asks about the number of active employees at the beginning of the plan year and at the end. So the IRS can just look at these Form 5500 filings and try to find whether there's been a partial plan termination. They have a whole project devoted to this. They go through the data, and if they think that a partial termination has occurred, they'll send a letter and ask you for all sorts of information about it. And of course, that never happens like the next year. It's always years later, and it could be a real problem for you to go back and correct it if you missed it. But that's one way. Another way is if you terminate the entire plan, you often ask the IRS for approval for that. And in connection with that IRS approval for the complete plan termination, so this is where you've decided to terminate the plan, 100% terminated. In connection with that, the IRS asks a number of questions that are designed to uncover previous partial plan terminations within the previous 5 years. And then if you're in the process of potentially selling your business, a buyer may ask about this, may ask questions to figure out if there's been a partial plan termination, because if there's some risk there, the buyer will want to know about it. So it's just good to be aware of this rule and be able to handle it if it comes up. Like I said, these situations are manageable when they're identified. You just fully vest the folks that are affected. Much more difficult to address if happens if you discover it years later. Like I said, these plan terminations come up in a lot of different contexts. And also, we have some employers who just say, you know what, I'm not really sure if I have a partial plan termination here, but we are doing a layoff here and we're letting these folks go. You can generally also sort of voluntarily vest people who are affected by a layoff like that, or by a sale of part of your business. You don't actually have to wait until you've triggered this partial termination rule to do this for employees. So I think that's it. I don't know, Tripp, I know we're at the end of our time here. Did we have any questions that came in that you think I should answer?
Yeah, we have one question at this point. So an employer has a 401A defined contribution plan. All contributions are made by the employer, no employee contribution. But there is a 5-year vesting schedule for the employee to be fully vested. Would that type of plan be subject to these partial plan termination rules?
It would, yes. Yep. Yeah, I mean,
all right.
It's tricky with 401k plans because with a 401k plan, you're sort of 100% vested in the deferral part of it. But the partial termination rules apply to any employer contributions that would be subject to a vesting schedule. So in that situation that you described, they just don't have the 401k sort of part there to worry about. But no, so yes, it applies to that plan.
All right, thank you very much, Jeff. With that, we are all out of questions, and that's right at about 12:30. So we will cut it off here. Again, please join us for our monthly lunch update, or employee benefit lunch break. You see, they're so new, I'm even having a hard time remembering what we're calling them. Next month, which will be the last one of 2020. And we will do our best to try to be a little bit more specific as the topic before, in our advertising materials or promotional materials for that. The other The other issue I want to address is we've decided that we are going to make the recordings of these webinars available on YouTube, on Miller Johnson's YouTube page. So there will be a separate playlist set up on Miller Johnson's YouTube page that contains just these lunch break series. And if you would like a copy of the slide presentation or the PowerPoint presentation, feel free to email me, or in this case, email Jeff. And our emails are on the screen, and we'll make sure that your email gets routed to the appropriate person and you get a copy of that PowerPoint. With that, thanks everyone for joining, and have a great afternoon, and we look forward to seeing you next month. Thank you very much.
Thanks, everybody.